Hello and happy Saturday. Welcome to Defense Diaries. I am your host, Bob Mata. And today, Saturday, August 2nd, a rare Saturday show for us. We are going to let me first introduce my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So tonight, babe, we're going to continue our coverage of the Aaron Spencer case, which is a case that we will be covering very, very intently. All
right, so give the people a little background that don't already know about the case.
Okay.
And we've decided to give you our the background of this case right from one of the pleadings. So
a state pleading, or actually a defense pleading, but
and then I'm going to follow it up with some info from what the facts the Supreme Court mentioned.
Right. So this gives you a little bit of an idea. Did you not want me to show it?
It doesn't matter.
Well, if I don't pull it up, then I'm reading a side screen, which you told me I look stupid when I'm doing. You look ridiculous when you're doing that. All right. So
I was hoping we could turn this into a podcast, but you've already gone south. So
what? Darren can cut all this off. He turns these into podcasts for sure. Darren, cut all this out. So on November 27th of 2024, the state of Arkansas charged Aaron Spencer with murder in the second degree, with an enhancement adding up to 15 years imprisonment for using a firearm connection with the offense. The charge resulted from an October 8th of 2024 death of Michael Fosler. The case has garnered media attention because Spencer killed Fosler while Fosler was having already been arrested and charged with numerous sexual offenses against Spencer's child, had Spencer's minor daughter in his custody for the purpose of R-ing her or worse. Fosler had previously been arrested and charged with 43 felonies for his conduct with Spencer's daughter, including internet stalking, SA, and child P. This court released Fosler on a paltry bond. So when they say this court, they mean this judge, this exact same judge who is presiding over Aaron's case was the very same judge who issued a ridiculously low bond on a 43 count case against Michael Fosler. He got out for $5,000. He was walking the streets some 3 months prior to the events that Aaron was arrested for. So, as I said, Fosler was released on a paltry bond with an order that Fosler could not have contact with the Spencer family. Undeterred by his arrest, Fosler continued his crimes against this child. About 3 months later, after finding his daughter missing in the middle of the night and contacting police, Spencer located her with Fosler, who fled with her in his truck. After Spencer pushed Fosler's truck to a stop, Fosler continued to present an imminent threat to Spencer and his minor daughter, the key witness in Fosler's pending criminal case, and Spencer killed Fosler, saving himself and his daughter from further harm at Fosler's hand. So that's
down to the other highlighted portions, babe.
Okay. The facts of this case are not in great dispute. it seems from the state's comments and the charge that it will seek to suggest that Spencer killed Fosler solely out of anger or revenge instead of fear, despite the undisputable facts. I think it should be indisputable, Raby. What do you think? Indisputable or
Indisputable.
Indisputable facts that led to Fosler's death. It is, of course, the state's prerogative to choose charges and theories. However, this theory is entirely inconsistent with the law. The Spencers, like any parents of a child harmed by a predator, were certainly angry and upset by Fosler's abuse of their child. But even if he'd wanted to, Spencer did not kill Fosler after finding out about the abuse. He let the justice system proceed to stop and punish Fosler. But when the system failed and Fosler took the child to harm her further, angry or not, Spencer did what was necessary and justified to save her. Here, there is little doubt that Spencer was justified in killing Fosler, and no reasonable person using common sense would consider these circumstances and find that Spencer was not fearful for the safety of his child at the hands of a man who would repeatedly hurt her for months. Is that all of them, babe?
That is it. And then I just wanted to read. So that information that Bob just read to you comes out of a defense pleading that was a motion in opposition to the state's request for a gag order. So that was ultimately appealed to the Supreme Court. Now, I just want to say the Supreme Court wrote in their ruling that he was charged on September 27th, but it looks like it was about September 4th. According to the docket, he was, sorry, my computer decided it doesn't want to cooperate. So there was like September 4th, they filed like the information, and on the 5th, there was a motion for discovery, and then there was a waiver of arraignment by Michael Fosler on September 5th, and that set trial for pretrial December 3rd, trial December 4th. So for all intents and purposes, it was going on the 3rd. And, then on October 8th, he kidnapped Spencer's minor daughter. So this was all very fast. So anyway, turning to the Supreme Court's rendition of the facts. They said on November 27th, 2024, Spencer was charged with felony information. And I think that might have been the date of the information. So that may be why they use that. With second-degree murder, along with a firearm enhancement under Arkansas Code. And they cite the code for the shooting death of 67-year-old Michael Fosler. The state alleged that on October 8th, 2024, Spencer knowingly caused Fosler's death under circumstances manifesting extreme indifference to the value of human life, a Class A felony under Arkansas Code annotated, again, citing the statute. Now, this is what I found interesting. They go on to say the circumstances of the shooting were as follows. In July of 2024, Fosler had been charged with numerous SO offenses against Spencer's teenage daughter, and he was released on bond. On the night of the shooting, Spencer awoke to his dog barking and the realization that his daughter was gone. Spencer found a hoodie on a stuffed animal placed in her bed. As a result, he left in his truck, searched for her. Spencer located Fosler's truck with his daughter inside, and he forced Fosler's truck off the highway. After an altercation, Spencer called 911 to report that he had shot Fosler. Fosler died at the scene. So from what I'm understanding and gathering from what the state is trying to present, and as Spencer's lawyer mentioned in her responsive pleading, the state's trying to say this was like an intentional planned thing out of anger. He hunted the guy down. I don't know. First, they were charging first-degree murder. For the life of me, I can't understand why. But for the Supreme Court to go out of its way to mention some facts, those facts seem to not be in dispute, or at least the Supreme Court has found them to not be in dispute. That's the fact that Aaron Spencer awoke to his daughter missing in the middle of the night with his dog barking, and so this can't be a planned, I'm going to hunt this guy down and murder him for what he did to my child. This all happened very quickly. He's out looking for his missing daughter, and this is what occurs. So it'll be interesting to know how the state intends on establishing that there was some sort of, that this was all about anger. And I guess they moved away from first degree, so they don't have to establish pre-planning, but it seems that they're trying to present facts in this way. So anyway, babe, what do we want to start with?
All right. And I know that you kind of didn't want to cover it again. Of course, our lawnmower guy decides to come at 7:00 on Saturday. Can you guys hear that in the background? If so, there's nothing I can do about it.
No.
I kind of want you had kind of poo-pooed it, but it's a very short concurrence from the Arkansas Supreme Court that I thought just there was enough kind of it's worth reading. I think it's short. Did you see Ollie's face?
No, I was just going to explain what it was you're talking about.
Wait, the concurrence?
Well, yeah, of what? For what?
Well, go ahead. Explain that. I guess I am assuming that most people have watched our first episode were you on?
So in any event, there was the defense appealed the gag order that the judge issued, and the Supreme Court ultimately found that it was overbreadth, ambiguous, unconstitutional, and they vacated it. So of interest is what one of the concurring judges had to say about the sitting judge.
Yeah, and I actually did not play the video or run the video of the arguments. I read the entire decision. That's what we did the last time we were on. But I didn't read the concurring opinions. And the one that I want to read in particular.
Well, were you thinking of showing any portion of the argument? If I know you meant that's really what I poo-pooed, but if you'd like to do that, since you're already going to read some of the ruling, I'm all for it.
Yeah, well, I didn't pull it up. I didn't pull it up ahead of time. So you poo-pooed it. So I was like, I mean, the opinion's easy to find. So I don't know if the video of the argument is easy to find. You can read that, or you can maybe search for that. Because I don't think it matters if we show that. We all know that the gag was ended by the Supreme Court. So there's no surprise. It's not like, but if the arguments were interesting, then maybe we want to get to them. And it was an important issue because it's that thing where gagging and sealing seems to become the norm, and it's not supposed to be the norm, So, I mean, to me, it's just an ongoing.
Do you want me to go over Fosler's charges while you're looking for that, or you have it?
Do you want me to so you tell me what you want to do first, hon. I want to just read this concurring opinion.
I didn't know if you had it. Go for it.
I have that. I don't have the argument.
Oh, that's fine.
The video of the argument. That's what I don't have because you poo-pooed it. So I didn't look for it. And it didn't really matter if you poo-pooed that because I knew I could still read this. Okay. All right. So this is Nicholas J. Bronni, Bronni, Justice, concurring with the drafter's opinion. So public officials aren't immune from public criticism, judges and prosecutors included. Because the circuit court's gag order violates that principle, I join the majority's opinion granting the writ and vacating that order. But the sweeping order is only part of a troubling pattern of attempts to shield this case from public view, beginning with a non-public arraignment and ending with a handwritten note sealing, quote, the entire case from public view. We cannot allow that pattern to continue unchecked. So I'd invoke this court's superintending authority and reassign this matter to a new circuit court judge. See Steinbuck versus Pulaski County Circuit Court, and that was a 2024 case. Anything less suggests that what's happened so far is within the acceptable range of disagreement or administration, and it isn't. Begin with the gag order itself. On its face, that order targets a broad swath of people, barring them from, quote, expressing an opinion or making any comment, end quote, about whether evidence, quote, tends to establish the guilt or innocence of the defendant, end quote. Worse, the order itself was sealed, raising serious concerns about selective enforcement. And it doesn't explain why such an extreme remedy was warranted. Instead, just declaring it would, quote, help ensure all parties get a fair trial, end quote. Nor did the circuit court explain why it extended the gag order beyond what even the state thought was appropriate, broadening it to cover the defendant's family and even more significantly sealing, quote, the entire case, end quote. On the contrary, the circuit court entered that order just 6 minutes after the clerk docketed the defendant's 19-page opposition to the state's motion, or barely enough time to make a pot of coffee. It's a pretty good concurring opinion.
Yeah.
That approach cannot be squared with the First Amendment, and it underscores that the gag order wasn't a last resort, but an unconstitutional impulse. Context suggests why. The same circuit court that issued the gag order here also granted Michael Fosler's release on bail. It's that decision, which the defendant's lawyers called a decision to release, quote, a predator who, quote, repeatedly violated the defendant's child on a low bond, end quote, that set off a chain of events that led to the fatal confrontation that's the subject of this case. And it's that criticism that the state claimed and the circuit court effectively concluded justified gagging the defendants, his lawyers, and others. This sequence raises serious concerns. Indeed, if openness, quote, enhances the appearance of fairness to so essential to public confidence in the system, end quote, then secrecy has the opposite effect. It erodes trust. And that comes from Press Center Company versus Superior Court of California, Riverside County, 464 U.S. 501, 1984. The effort to shield these proceedings from public view also didn't begin with the gag order. It started with the circuit court's decision to arraign the defendant away from public view. And even setting aside the potential constitutional concerns raised by a non-public arraignment, that decision highlights the order on review here isn't an isolated problem. And then he cited, so it says discussing, and this is in parentheticals, discussing a two-part test for determining whether First Amendment rights to access to criminal proceedings attaches, citing Blackstone, and confinement of the person by secretly hurrying him to jail where his sufferings are unknown or forgotten is a less public, a less striking, and therefore a more dangerous engine of arbitrary government. Rather, it suggests a star chamber-like atmosphere. We cannot allow that to continue. Ultimately, judges and prosecutors enjoy, quote, no greater immunity from criticism than other persons or institutions, citing, and that's end quote, Landmark Communications, Inc. Versus Virginia, again, another Supreme Court case, 43 U.S. 829, 1978. Nor should they. Quote, public vigilance serves us well for, quote, the knowledge that every criminal trial is subject to contemporaneous review in the forum of public opinion is an effective restraint on possible abuse of judicial power. And then they cited another Supreme Court case, Morrison versus Olson, with Scalia dissenting, quote, under our system of government, the primary check against prosecutorial abuse is a political one. Instead, quote, justice should not only be done, but should manifestly and undoubtedly be seen to be done. So I joined the majority's decision granting the writ and vacating the gag order, but I would go a step further. The repeated attempts to veil these proceedings in, quote, secrecy can only breed ignorance and distrust of the courts and suspicion concerning the competence and impartiality of the entire criminal justice system. Remedying that danger warrants strong medicine, and I'd apply it.
Goes, I mean, it says a lot. I mean, this Supreme Court is saying, you guys are trying to shut this up so the judge doesn't look bad, the prosecutor doesn't look bad, like the police don't look bad, meaning y'all look bad, and it was pretty.
See, it's stronger than that. It's not only that y'all look bad, like he sniffed out that this thing stinks. And he pointed out why, that this isn't an isolated event with this judge. And it all starts with her giving him that ridiculous bond. She created the problem. And now she's trying to hide it. And this justice wasn't having it. So I applaud this justice for that scathing concurrence. It really is. I mean, he called out. I mean, that judge could not have felt very good about reading that. I mean, when you're a judge and you're sitting on the bench in the highest court in your state body slams you, you feel it. You feel it where it hurts. And she deserves it. So I don't know where Allison went. She just vanished into thin air. Oh, there she is. Hi, where'd you go?
I was listening to because I was like, all right, at this point now, let's just listen to the argument. But the sound is very low. It's 57 minutes. So I don't think it's something that we can do today. So I thought I was getting out of that, and I got out of everything.
All right. So what do you want to do next? Because there's something I want to get into that Aaron's wife put me on in terms of something that was posted on Facebook. And it was something that occurred in February.
No, I think that's a good idea.
Because it's interesting. It's interesting. And when I say that she put me on it, I meant I found it on her Facebook page. So she shared it on her Facebook page. So this thing comes from it's well, I'll read it, but this was a post about Cabot Strong. Now, Cabot is probably the biggest city. I believe it's the biggest city down there in Lonoke County. And this, I think, was posted, I want to say in February, maybe. Okay. I'm not seeing the date that this, so January 25th. Okay.
Which is a month and a couple weeks.
Right.
2 weeks after.
Yeah. So this is like the stories out there. You can imagine that the community is up in arms, and they decide to post this thing, and it's Cabot Strong. I'm going to blow it up so y'all can see it. And this is on this Cabot Strong Facebook page. Okay, and it's posted by Adam Sims, January 25th. Reminder, I've received calls as to if we were having a community meeting tonight. The answer is no. Please read all the way through the post. After consulting with the Lonoke County Sheriff's Office, we are postponing the January 25th community meeting. We're moving everything to February 22nd. It will be held at the South Bend Fire Station on Highway 294. We will eat at 6:00 and the meeting will start at 6:30.
Wait, can you make it a little bigger? And did you say after meeting with who? After talking with?
Consulting with the Lonoke County Sheriff's Office.
And who is the person that is this post is? Is this a police officer, a person in the community?
I don't know if Eric Sims is just the person who runs this page, or Adam Sims. He's not one of the people that that would be attending the meeting that was going to be one of the panelists? Because I'll get to it. I'll get to it. But I don't know who Adam Sims is.
Okay.
He may just run that page, Cabot Strong. But whoever he is was more than happy to put this up. So the reason for this is because of how important this topic is. Shoot or don't shoot. Attending this meeting will be Sheriff John Staley, Prosecutor Chuck Graham, who happens to be the prosecutor prosecuting Aaron Spencer, and Circuit Judge Sandy Huckabee, who is not the judge who's sitting on the case.
But a judge in that same county?
Yeah.
Wow.
We will have body cam videos of our deputies having to answer the questions of shoot or don't shoot in real time. If you're asking how does this apply to our community, it applies in two ways. One, it will give the public a better understanding of what our deputies face every day. And two, it'll answer any questions you might have about having to protect yourself or family should the need present itself. I believe this meeting will also clear up some misunderstandings that are a common thought from past and present actions taken. We elect people with the expectation of them to abide and administer the laws as presented. If the court of public opinion does not align with the laws as written, it is a let me see what this is say.
Hey, is your audio set to automatically adjust? Because Mandy's saying turn your volume up a little.
Oh, I think so. I'll check though real quick. I think it was the lawnmower guy behind me was like causing the thing to do something. Oh no, yeah, it's not. Okay. All right. Okay, so if the court of public opinion does not align with the laws as written, it is a state issue to be addressed with our state legislators. Criminal laws are not derived by local governments. Examples: the quorum court has the authority to preserve the peace and order and secure freedom from dangerous and noxious activities, provided, however, that no act may be declared a felony. We cannot pass any laws to declare any actions a felony. That is the state legislator's power or powers. We can bypass an ordinance for the people to use in the court system, but even then, we can't declare a felony as a charge within the ordinance. An example is our dangerous dog ordinance. It lists definitions of a dangerous dog, actions to be taken by the owner of said dog, and fines to owners that don't take the actions required to own a dangerous dog. It does not list any felony charges. It is a tool used to protect people. Our sheriff's officer administrates the law as written by our state legislators. They are responsible for upholding the county and the state laws and maintaining public order. They are the chief law enforcement of the county. They have jurisdiction over the whole county, including the cities within. Again, they do not make the laws, but they are required to enforce the laws as written. You can see where this is going.
Yes, you can. Finish it up and then let's tell us how the people sniff this out.
Yeah, and I have zero doubt that sheriffs all across this nation have questioned laws as written when they are forced to execute them. The prosecutor's office that is responsible for the process of investigations and court prosecutions. They have to determine: one, criminal act, any unlawful act or unlawful omission of an act that takes place. Two, criminal intent. A defendant can only be held culpable where there is criminal intent. Three, concurrence. Concurrence refers to the coexistence of criminal intent and a criminal act. Four, causation, the relationship between the defendant's conduct and the end result. While our judicial system and the citizens they protect are mutually exclusive, the same question is asked by both several times as the wheel of justice turns on each court case. Quote, is this justified? Does it meet the burden of proof set forth in our laws? End quote. It is not judged through the court of public opinion. It's judged by laws codified with which precedent has been set and followed by all.
Wow.
Yeah.
I hope you actually print this so that if it disappears, well, it's here on this live anyway. Never mind.
Uh, the last thing a citizen thinks of while their home is getting broken into is, quote, will it be justified if I shoot to protect my family, end quote. It is a split-second decision when feeling threatened. It's only after the dust settles and everything is scrutinized that the determination is made by the others based off the laws written, not by how someone feels it should be judged.
Wow.
Yeah,
Wow.
yeah,
This is outrageous.
yeah,
This is like so transparent. They were sitting in there shitting their pants like our whole, this entire community is going to say that this was justified. We need to start laying the framework now, laying the basis now for why it's not.
yeah. Some cases are difficult because we might know the heart of a person being charged. While that plays a factor, laws are codified and set in stone to prevent emotions from dictating justice. For every action, there is an equal and opposite reaction. Just as much as one might feel something was justified, there is someone else that feels it wasn't. Laws are written to bring justice, irregardless. And
Which is
by
not a
the
word.
way, irregardless is not a word.
Not a word.
It is my intention to help everyone make the right decisions when faced with harm from bad actors. Example, did you shoot through the bedroom door thinking it was a bad actor, but in reality, it was a family member? 2, was the threat running away or coming towards you and your family? 3, was the threat legitimate? Did a daughter invite her new boyfriend to sneak into the bedroom window and talk? Wow. I mean, to talk, and you as a parent open the daughter's door to see a man in her room and you think that it was a bad actor, then shoot thinking he was harming your daughter. This meeting will force those that attend to answer questions like this in advance of it
But
being scrutinized.
oh, sorry. I thought you missed a part.
No, by others to determine if it was justified by law. Different scenarios will be played out after the videos. This will be interactive with those attending the meeting. We will have non-lethal training props to act out live situations you might face. My goal is to make sure that everyone leaves the meeting with a better understanding of the laws related to this one. No one wants to be put in this type of situation. However, the more prepared you are, the more likely your decision will be correct. I expect this community meeting will be standing room only. Plan to get to the fire station early. I will have Matt Dreyer lined up to serve his barbecue all day until 6:15 p.m. If you wish to eat before we start, be at the South Bend Fire Station on Highway 294 before 6:15. The meeting will start at 6:30. We will not answer any questions about pending litigation.
Oh, really? Pending litigation?
Yeah.
I wonder which pending litigation they're
Yeah,
talking
what are they
about.
talking about? I
What could
wonder.
they be referring to?
Oh my God, I have no idea. I know some are very passionate about their cause, but this meeting will not be turned into a Jerry Springer show. We will ask you to leave. If you don't, you will be escorted out. If you still want to act foolishly, it will be handled by the deputies attending. This meeting will be about helping people make split-second decisions to protect themselves and family, not about advancing a case in the court of public opinion. Really?
You're literally trying to advance a prosecution case in the court of public opinion.
Oh my God.
My goodness.
So forgive me for canceling January's meeting, given the fact that we are now thawing from several weeks of below freezing temperatures and the sickness making its rounds. I felt the safety of everyone attending should play a factor and canceled it. If you need something addressed, feel free to message me. I will forward the issue to the office holder it may concern, advocating on your behalf. So
How did the community respond to this? Did it take place?
it did not.
Hmm.
So it didn't take place in February. The community was outraged. And you can see on Heather's page, there were some comments, and this is from months ago. So
We can't see them.
okay, I'll see if I can get it over here. You can see them a little better.
Yeah.
So Justin Boxell says this is completely to sway everyone's opinion or sow doubt by hearing only their side, not giving Aaron's side a chance to be heard till this is already deeply ingrained in the citizens' minds, keeping in mind the same citizens the jury the jury pool is coming from. So I can't. Oh, yeah, coming from this jury. This is jury grooming. Well, what they really call it is indoctrination.
Yep.
They're indoctrinating the jury, or they were trying to.
Yeah, they were definitely trying to pollute that jury pool.
Yeah, there's no question. I mean, more than pollute, like they were really trying to indoctrinate them.
Yeah.
Like,
And fight against what they saw as potential jury nullification, which is jury nullification is, let's say, and that's not the facts here, but let's say that Aaron just sought him out and slaughtered him for what he did to his daughter. Jury nullification would be like, we don't care. We're going to give him not guilty. That's how we see it. And juries have every right to do that. They can fly in the face of the law and make their own decision. So, but go ahead.
yeah, I mean,
wait, you minimized them.
well, it's hard because they're over on the side. So, because like I'm on a Facebook page, so it's like, so, but Pamela Hart McGahee said, this makes me angry. They tight-lipped the cause, but then they pull this, grr. And Michelle Howard had said, this is what I just read. Experienced manipulators are justified. We're going to have a meeting to manipulate the public so we can win.
All right through it.
Yeah, don't say it's about the Spencer case, but say it's about the Spencer case. So, yeah, this thing didn't happen, thankfully. And, clearly at that point in time, it was obvious that this thing in the community, that they were facing massive blowback, as they should be. And as we continue to cover this thing, and I'm here to warn you, down in Lonoke County, I'm going to be there. I'm going to be there for any hearings. I'm definitely going to be there if there is a trial, if they decide that there is going to be a trial. Well, we disagree with Peter, and I love Peter, but I don't think it's a jury nullification case. And we're going to go through that here. We're going to pull up the defense of others statute, and I'm assuming Allie has the self-defense statute from the Arkansas statutes.
Well, why don't we start with the three that the defense cited. Sorry.
Take your time, babe.
All these windows open now, because I was also going through the potential. Arkansas has some really crazy laws related to SA and of children and kidnapping, even, and the charges, but we can get to that. We can get to that afterwards. Let's go to.
Yeah, it's really a defense of others, Ray, more than self-defense, in my opinion. Well, but jury nullification is exactly what Allison said, and that's where the jury decides to ignore the law, and they refuse to follow the law, and they come back with the not guilty, even though the law supports a conviction. Here, I don't believe, any part of me doesn't believe that the law supports a conviction. I think when we pull up the statute, when we get to it, you'll see defense of others. I think it's on all fours with it. So, like the bigger question for me with this case is the prosecuting attorney in this case is a elected official. Okay. I cannot think of a quicker way to be elected out of office than to move forward on a case like this, because any parent of small children or teenagers is going to firmly believe that Aaron did what was justified, did what was necessary in order to save his daughter. And there is going to be no way in hell that he's getting convicted on this. Yet they decided to move forward on this case in light of that. And I don't know when the election's coming up in Arkansas. But if this guy moves forward and his name's Chuck Graham, and from what I hear, he's been a prosecuting attorney down there for a while, for a hot minute. And this case in particular, when we start digging into Michael Fosler, which we'll be doing heavily, it becomes very clear to me that there's some kind of agenda beyond what we know as the public, because it's nonsensical. This, as Allison said, this isn't a situation. This guy was out for 3 months, out on bond. If Aaron wanted to harm this guy, and this was vigilante justice, he would have done it at any point during those 3 months. It wasn't until this monster got his filthy hands back on his daughter. And if you're wondering how Aaron's daughter ended back up in the truck, it matters not. This was a 13-year-old girl who was groomed by a 67-year-old super creep.
No, at that time she was, I thought you said 14 or 15.
When she was groomed initially. That's when this starts. It doesn't start when he gets out.
Yeah, but I think it was 14.
She was 13 when this started. It was 14.
What age was she when
this incident occurred? She was 14. When he started grooming her, she was 13 years old.
Right, because the charges of his offense were all June 1st of 2024. So, and I'm only asking that because the statute makes a big difference between 13, 14, and 15 at different, depending on what we're talking about. So, before I go into the defense of others, I thought, based on what you were just saying, it's a good time to share the statement the defense put out leading up to the gag order. So I'm going to do that.
Did you find the cases you were trying to pull up?
Yeah, I have everything that I need.
Because I was trying to kill time.
No, but it leads well into this. Okay. So late Wednesday, Spencer's attorneys, Aaron Casanelli and Michael, is it Kyle or
Kaiser?
All right, Kyle.
Kyle Kaiser or Kyle.
I'll just say
I think Kyle is his middle name.
Right, Michael Kaiser released a statement that read, "We are not just disappointed, we are outraged by this decision. Aaron Spencer is a dedicated war hero who decorated war hero who protected his family and a loving father whose heroic actions protected his family. He is certainly not a criminal. He did what any father would do and any trained combat veteran would do to protect his child from a predator. This predator repeatedly violated his child, and undeterred by criminal charges and release on a low bond that pales in comparison to what was required of Aaron, kidnapped her in the dark of night to continue his assaults on her. The systemic failures for decades that permitted this man to continue his abuses of women and children for years culminated in his facing a father who finally stopped him. No matter what the prosecuting attorney may do to Aaron, he was able to save his child and prevent this man's continued acts of sexual violence against the most vulnerable among us. Nothing could be more important than that. While the prosecutor has made it clear his intent to send Aaron to prison, even targeting his use of the legally owned firearm, and in spite of his past experience in combat in this country, it is not the prosecutor who ultimately decides justice. It is the citizens. We believe the citizens of this county and of this state will not allow this injustice, and that this community will not allow a father protecting his child from a serial predator to be treated as a criminal. The repeated traumas Aaron's family has endured over the last 6 months are unimaginable. Sadly, the prosecutor's decision perpetuates these horrors. Sorry, I was like about to hiccup and was fighting it. Perpetuates these horrors instead of protecting legitimate victims and punishing true criminal offenders. Instead of targeting this heroic father, the prosecutor should be working to figure out how the system failed to protect this innocent victim and instead resulted in her father having to do so. We appreciate the support of so many who have voiced their outrage over the treatment of Aaron, his child, and the rest of his family, have suffered. We will stand up and fight for our right to protect ourselves and our children and will not be deterred by this unjust decision. Please keep Aaron and his family in your prayers as they continue to heal from past events while now managing a criminal case. We look forward to Aaron's day in court and to the end of this family's nightmare.
Yeah, and if you and I talk about it on this channel all the time, that the process itself is part of the punishment. Aaron Spencer is having to live with this thing, this case hanging over his head every minute of every day of his life. And that's coming out of and still dealing with the fact that they became aware that their child was being abused by some 67-year-old creep.
Yeah, and what about the child? She's got all this trauma, she's suffering all this, and now they're charging her father?
Yeah, and ironically, I mean, who do you think is going to have to take the stand in order to get her father walking out of that courthouse? This child. Like that
This whole thing
child's
baffles me.
trauma just never ends.
No.
It never ends.
All right, so here are the defenses that have been named by the defense. So the defense has to give notice, and they gave notice of three statutes. So the first is 604, choice of evils. So A, conduct that would otherwise constitute an offense is justifiable when the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and according to the ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. B, justification under this section shall not rest upon consideration pertaining to the morality or advisability of a statute defining the events charged. C, if the actor is reckless or negligent in bringing about the situation requiring the choice of evils or in apprising the necessity for his or her conduct, the justification afforded by this section is unavailable in a prosecution for any offense for which recklessness or negligence, as the case may be, suffices to establish a culpable mental state. So that is the first one. Now, don't forget here, we're dealing with, I'm not sure if they charged him separately with like running the guy off of the road, but there was other conduct also short of just the shooting itself. So why can't I find okay. The next one is 606, which is use of force in defense of a person. And that I would say would probably be the non-deadly force, because the next one deals with deadly first. But a person is justified in using physical force upon another person to defend himself or herself or a third person from what the person reasonably believes to be the use or imminent use of unlawful physical force by that person, and the person may use a degree of physical force that he or she reasonably believes to be necessary. 2, however, the person may not use deadly force except as provided in 607, which we'll get to next. So when you deal with the reasonable belief that physical force was necessary to defend yourself or a third person from the use or imminent use of unlawful physical force by that person, it's very safe to say, first of all, I want to say that kidnapping is a violent offense, and but I'm going to get into it in 607. But depending on how this occurred under the law, kidnapping might not be the predator, the the precursor that we want to use as far as the use of deadly force, but I'm going to get to it. So sorry. A person is not justified in using physical force upon another person if, with the purpose to cause physical injury or death, the other person provokes the use of force. So these are all things not relevant here, whether the person's the initial aggressor, and then they give an exception for even if you are the initial aggressor, if you tried to walk away or stop it and the person kept coming at you. And then C, a person who uses or threatens to use physical force as otherwise permitted under the statute does not have a duty to retreat before using or threatening the use of physical force if that person is lawfully present in the location, which he would have been, because he would have been lawfully justified to run that car off the road under the statute we just read and under this statute. He did not engage in criminal activity that gives rise to the need to the use of physical force. Again, this would not be considered criminal activity because, again, I'm talking about running the car off of the road. And C, not engage in any activity in furtherance of a criminal gang organization, which obviously was not the case here.
See, I think it falls squarely under A1.
I would absolutely agree. It's clear that if he was not already using physical force to keep her in that vehicle, and we don't know what she's going to say. We don't know what happened. In any event, it's clear that it's reasonable for him to think that he was about to use imminent use of unlawful physical force in continuing his abuse against this child. And we don't want to get, knocked down here by saying SA. So I'm just going to call it abuse, but you guys all know what we're talking about.
Because when you look at the facts of the case in terms of, because when we start digging into Fosler, and Allison always likes to remind me, well, what Aaron Spencer didn't know about this guy isn't going to play into the equation. And she's absolutely right. It won't.
He knew enough.
He knew enough. What he knew is that this guy had abused his daughter. This guy had been charged with those offenses. He was going to be standing trial, that he was afforded a ridiculously low bond in which he got out. And that
in the middle of the night, he took her daughter or caused his daughter to leave.
Before that even happens, there's a stay away order where Fosler is directed not to have any contact with the child or the family. And he knows that somehow this guy has gotten his claws back into his daughter because she's with him. And again, I'm gonna state it as he's a 67-year-old man, and at this time she's a 14-year-old girl. Like, I see people making comments, well, how did she get in the car? I don't give a shit.
He either lured her out or he physically came in and took her out.
It doesn't matter. She was groomed. Whatever he said to her got her out of the house because he had groomed her.
Right.
And that's what Aaron Spencer knew. And he
knew
that
he was going to either kill her or continue to abuse her.
Put yourself in that situation where you've got this guy who's staring at 43 different charges. He's got a trial pending. He's out. He's 67 years old. He's got a stay away order, and he still is coming after your kid. This guy does not give a fuck. That's what I'm thinking.
Right.
I think this guy has no regard for the law. And what is scarier than somebody who doesn't give a shit? There's nothing scarier than somebody that doesn't give a shit
and has nothing to lose.
And nothing to lose. So
he either gets rid of her
in Spencer's mind.
Right. And I don't think there's any person that would think it's not reasonable for him to believe that he is getting rid of her forever so she can't testify against him and or going to continue to abuse her. So the use of deadly force. All right. Obviously this is the most important of all the defenses that we've gone over, but a person is justified in using deadly force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving physical force or violence.
That's where this case lives.
Right. And it technically it actually lives in about to commit a felony because under Arkansas law, this is outrageous to me. This is outrageous to me. I'm not going to be able to find which window I have it open in now, of course. I'm just going to go back to.
Yeah, and I'm just going to say, if you're out there still wondering, look up what grooming is. Because it seems that there's some people, I've seen a couple of people in chat that I don't think that you have a real firm grasp on what the concept of grooming a child who does not have a fully developed mind by a 67-year-old predator, and the kind of influence and sway that person would have over that child still, even after he's been arrested, even after he's been charged.
So I just want to tell you why I'm saying that under the law, they could find that he had not committed kidnapping. So he wasn't already committing an offense, but he was committing the offense of violating a court order, and all of that I think is obviously important. But I found this shocking. Kidnapping in Arkansas is defined as a person commits the offense of kidnapping if, without consent, the person restrains another person so as to interfere substantially with the other person's liberty with the purpose of facilitating the commission of a felony, inflicting bodily injury, or terrorizing the other person. So then I was surprised. I'm like, wait a minute. Why isn't it defining it as without a parent's permission, you take a child? And I went back to the statutes itself, and they define restraint without consent to include either A, restraint by physical force, threat, or deception, which could be the case here, right? Because it could most assuredly did actually deceive her. So there is restraint by that. So I do think for that reason, it actually does fall into kidnapping no matter what you think. But this or really got me. In the case of a person who is under 14 years of age or incompetent, restraint without consent of a parent, guardian, or other person responsible for the general supervision of his or her welfare. So, and I read some horrifying cases where the person is over 14 and some predator has them, and they're like, well, they didn't restrain him, he didn't threaten him, they didn't do anything, so it wasn't kidnapping. It's other things.
Read that to me again. Just the age part.
Right. In the case of a person who is under 14. So 14,
if you have reached the age of 14, it does not apply. Is that what you're saying?
Right. So restraint without the consent of a parent. So if you're 13 and you don't have the consent of the parent, that fits in the definition of restraint without consent, and it's kidnapping. If the kid's 14 and you haven't physically restrained them, threatened to restrain them, but again, it does have that deception in here, and that's key for us here, because all of everything that anything that this man would have said to get her out of the house would have been deception, including, I think, the entire grooming process. That is just an ongoing act of deception, and I think the courts would be inclined to find it fits into that definition. But I was just shocked to find out that the courts have applied that, where somebody's 14 years of age, and even a person that was with this child for the purposes of a sexual encounter, sexual conduct, sexual contact, trying not to use the words that will, get us hit. And they're like, well, it's not kidnapping. It doesn't mean it's not other things, but it's not kidnapping. So, in any event, let me go back to.
Yeah. Well, my thing is that I think he was going to either abscond with her out of state, or he was going to end her life.
Yeah.
She is the only witness against him. And
Oh, I think he most assuredly it's reasonable to think that
Aaron
he would have ended
Spencer
her life.
doesn't do what he did that night. They never see their kid again. That's the way that I
No.
feel about it.
No.
And no one's
Absolutely.
convincing me otherwise, ever.
No. So then you've got 2 is using or about to use unlawful deadly physical force, which I believe it was reasonable for Aaron to believe that that's what this person was going to do. Or 3, or imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. Which what's happening? Do you hear that?
Yeah.
What the hell?
It's somewhere on your computer.
I know. I'm looking through all I have open are law windows. Wait, what's this? No, Arkansas. Why would it just start out of the blue like that?
I have no idea. You're asking the wrong dude. Takes me
All right.
half an hour.
Oh my gosh.
Who's playing what? What instrument?
Weird. I can't make the
Hey, oh, Allison.
All right, I'm going to keep this window open and like that's it and just close everything, but I'm telling you I checked every window that I have open. That window, and this is horrible.
Probably Apple Music just randomly playing.
Oh, good, maybe.
Yeah, I would hit that and something.
It's not open.
No, what do you mean it's not open?
It's not open. It just stopped on its own. Oh no, now it's starting to do something else. That's definitely somebody.
What do you mean somebody?
Like it changed. Someone somehow, maybe it's Scarlett somehow. How do I?
So this, if you look at our low banner here, that would be the tech wizardry. What you're seeing, it's not me. It's not me. I'm not doing it.
I just unplugged the speaker it was coming out of.
What?
Can you still hear me?
Yeah.
That
Wait,
big
what?
speaker that Darren has down here.
Do you have your headphones on?
Yeah.
Huh.
It was playing so loud. It was coming out of the speaker.
No, Scout does not listen to jazz.
What is happening?
Hey, Moscow Mules. What did I just order?
Dude. It's coming out of the television now. Just started. Turned on.
All right.
Wait, is the TV on? All right, hold on.
TV's not, but the speaker system just came on.
You talk to the people. I'll figure it out.
Okay, guys, we do not use the TV down here. We do not use any of these speakers down here. And it's on the other side of the room, the complete other side of the room. It's kind of freaking me out. And now it just stopped. I was just telling them that we don't use this TV. We don't use that speaker. How it even turned on, I don't know. Isn't that weird?
I don't think you. What do you mean you unplugged that?
Yes. I pulled out the cord that went into the back of the whole system here.
Just the one speaker?
Yeah, the one speaker. Sorry, guys. Wow. Yeah, it is. It's tech paranormal wizardry. Exactly. I mean, that is really, really weird. Like, I don't even think Scarlett's in the house right now. Daisy's asking, do we have like a device? It's a secure device. Like, I don't even know how the neighbor could hack into, like, that was the speaker set up to the television that just started playing, like the surround sound for the TV. Wow. All right. And I closed down all my freaking windows too for no reason. So, in any event, I think that, with these, um, I'm not sure whether it would be the continuing pattern of domestic abuse, because they define domestic abuse as abuse by a family or household member, and that's not the case here. But it definitely, falls into 1 and 2. Um, it goes on to say that a person is not required to retreat before using deadly force again if that person is lawfully present at the location where the deadly force is used, which I think he was. He was, and has a reasonable belief that the person against whom the deadly force is used is imminently threatening to cause death or serious physical injury to the person or another person. That is also true here. Um, and then they go back to 606, which we just read about not being the aggressor. Is not committing a felony offense of possession of a firearm by certain persons. He was not. It would be something like, if you were a felon and you're not allowed to possess a firearm. I did actually look up the statute, but it wouldn't apply to him. Is not engaged in criminal activity that gives rise for the need of the use of deadly force. Also not the case here, and is not engaged in any activity in furtherance of a gang. So, and again, they actually define domestic abuse: physical harm, bodily injury, assault, or the infliction or fear of imminent physical harm, bodily injury, or assault between family or household members, or any sexual conduct between family or household minors, whether adults, minors, or adults, that constitutes a crime under the laws. So those are the 3 defenses that were raised. They very clearly, um, apply here. I
Yeah.
believe, and I don't know.
I mean, and that's why, in my estimation, this will never be a jury nullification issue.
Right. That's going back to exactly what someone mentioned about Peter saying there would be jury nullification. We don't think that the facts of this case are going to establish the need for jury nullification here.
Yeah, and
If they do, then absolutely this is a case for jury nullification.
right. And Alice and I have had the debate about the case off air, about whether or not, the state can come up with some kind of fakakta crazy theory, just out of the blue. And I was telling her, like, yeah, they can. I mean, every case is just a theory by the state. I mean, it's got to be, at least they have to be able to kind of tie it in with the evidence, but I mean, who knows what the state of, will come up with as far as the theory goes.
They didn't present enough to the Supreme Court. Remember, the Supreme Court found, and that's why I started with that he was awoken by the dog barking, found his child not in the bed, found a hooded stuffed animal where the bed should be, and left to go look for her, and found her in his vehicle. So if the state planned to put forth something different than that, they surely didn't establish it to the Supreme Court of Arkansas. And again, they didn't need to give that factual basis for what they were ruling on. They really didn't. They found it. I don't see how the state thinks they're overcoming that. And they're going to come up with a new theory now that they couldn't even present to the Supreme Court.
Okay, Trish says that Peter didn't say it would be a case for nullification. That would be a perfect case for nullification. That's a better assessment for sure. Because I don't see this as a jury nullification. Jury nullification, Debbie, again, is where the jurors decide to disregard the law, that the state was able to prove that the law was violated, but the jury feels that
I'm not going to
that the
convict him
facts
anyway.
of the case warrant that there's not a conviction. They can't. Their moral compass won't allow them to convict the person. That's where they're not going to follow the law.
And
that's jury nullification.
Right. And again, we believe that this fits right within those defenses that Aaron's defense cited.
Yeah, and that being said, all of that, whether it turned into a jury nullification, if the state was somehow able to argue to the jury and they felt like, oh well, defense of others doesn't apply here, jury nullification would then, I think,
perfect
without question. But either way, I just want to be clear that the prospect that is hanging over Aaron Spencer and his family's head right now, and the concept that you never know what a jury is going to do, is terrifying. It's terrifying. Sitting in that chair in that courtroom is terrifying. Going through the process is terrifying. All of it's terrifying for everybody involved from the Spencer family. I assure you. So, I mean, this is just a case that should never have been brought. And I mean, one of the things that we're going to really focus on here on our channel is bullhorning the hell out of this case. I hope I've seen a lot of people cover it after we covered it and Melanie covered it. I've seen a bunch of channels, and I'm always thankful for that. We need as many people out there saying, because this shit is outrageous.
Right. I agree with Kaylee. She says this case makes shit go crazy, literally. Oh, she's talking about in the house.
Yeah.
Jen said, sorry about your ghost.
Yeah. Yeah. Yeah, it's just one of those cases. And so kind of the newest thing in terms of anything that has popped up on the radar, there was a joint motion to continue that was filed when, Allie?
It was filed yesterday. And basically both sides are just agreeing that they need to continue this. Do you want me to pull it up, or do you want me to just summarize it?
Yeah, you can just summarize it.
That there's still evidence discovery that needs to take place, and that the state crime lab hasn't finished processing all the evidence. So the August, 8th date is stricken, and the trial date, well, they're asking for that date to be stricken and the trial to be stricken. When both sides ask for it, and with those bases in mind, I can see no other choice the court has than to continue it.
Yeah.
And that gives us time, because they can't shut us up. They can't gag us. I mean, I don't know if they've got any part of a gag left.
They don't have any part of a gag left.
Well,
but
if they did, they wouldn't.
They're not shutting us up.
They can't shut up us and the rest of the YouTubers.
Like what I wish that Bronny would have written the opinion in terms of
convinced all the other justices. I mean, if he had convinced all the other justices to do that, it would have been part of the majority.
I know.
Yeah.
And you're talking about him assigning a new judge.
Right, because he's saying this clearly shows her bias, that she was trying to keep this all hush-hush and under wraps.
Elmore should not be sitting on this case.
No.
Elmore should not be sitting on this case under any circumstances. To me, the fact that she's the one who put that ridiculous bond amount on this case and allowed that man to walk out. And I don't know how much he could have afforded. If it would have been $50,000, maybe he would have come up with that too. I don't know if they have what the bond system is out there. In Illinois, back when we had bonds, we didn't have bail bondsmen. You had to come up with 10% of whatever the bond amount was, meaning the judge sets $100,000 bond. You had to come up with 10 grand.
We still don't have bail bondsmen here.
We never had bail bondsmen, but a lot of states do. I don't know if Arkansas does. I mean, there's certainly states where bail bondsmen are a thing, where you go and say, oh, I'll put my house up, just come up with the cash. And the bail bondsman puts the money up. And then if you abscond, that's where you get Dog the Bounty Hunter guys chasing dudes down because it's their cash on the line.
Right. Right.
All right. What do you want to look at next?
I don't know. I was spent a lot of time looking over the charges against.
Well, I thought we should pull up the pipe. It just goes again. like, there's this part of me that keeps trying to understand what's really going on here. Like, what's really going on here?
Right.
Like, what, like, why are, like, this is not the case to die on a hill for if you're the prosecution.
No.
Oh, no.
And what so go ahead and bring those motions up. Bob's gonna bring those motions up. They deal with the charges stemming from a pipe that was allegedly found in the police car. Well, that was found in the police car. And it just doesn't make sense to me why the cop, unless it's like a fallback that they do, would be trying to, you know, pin it on him before they even know what's going on and who's involved and what they're doing, that they're already planning on planting this pipe on him.
All right. So this was filed back in February of this year. It's a motion in limine to exclude reference to an alleged smoking glass device found in a patrol cruiser pursuant to Arkansas Rules of Evidence 402, 403, and 404B. And Andrew White. So they cited case there. Comes now the defendant, Aaron Spencer, by and through his attorney, Michael Kyle of Lasser and Casanelli. And for his motion states, the state's discovery file alleges officers found a glass smoking device in the patrol cruiser where they were detaining Aaron Spencer at the scene on the night of the charged act. Spencer demanded a blood test to confirm that he was not a drug user. State did not file any charges related to the device. This court must exclude any reference to or evidence about the glass smoking device pursuant to Arkansas Rules of Evidence 401, 402, 403, and 404B, and pursuant to the United States Supreme Court recent decision in Andrew v. White, a 2025 case. Such evidence has no independent relevance and does not fall into any of the listed or known exceptions to Arkansas Rule of Evidence 404B, which is bad acts, prior bad acts. General prescription on character evidence. Further, any probative value that the evidence has, which Spencer does not concede, was grossly outweighed by the dangers of unfair prejudice and confusion of the issues. Rule 404B of the Arkansas Rules of Evidence provides evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Prior bad acts evidence must be, quote, independently relevant to the main issue, relevant in the sense of tending to prove some material point rather than merely to prove the defendant is a criminal. Lindsay v. State, a 1994 case. Even if relevant, under Rule 404B, evidence may still be excluded under the Arkansas Rules of Evidence 403 if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, all of which even a mention of there being a glass pipe would do. The state is not entitled to introduce evidence of other offenses to persuade the jury that the accused is a criminal and thus likely to have committed the crimes he has been charged with. Specifically, proof of other crimes is never admitted when its only relevance is to show the defendant is a man of bad character and or addicted to crime. The evidence at issue has no independent relevance to the charged act. Whether Spencer possessed the glass smoking device, something he bitterly disputes, has no bearing on whether he knowingly killed the alleged victim or whether he was justified in doing so. The evidence is irrelevant and inadmissible accordingly. So, and they cite Green versus State, which is a 2006 case, wherein they quote, Chad's testimony about smoking methamphetamines had no independent relevance to the state's case that the appellant committed the murders and kidnapping. Rather, it demonstrated the appellant was a drug user and a subject that was not an issue in the case. Instead, this evidence is the worst kind of propensity evidence meant to encourage the jury to find Spencer guilty in accordance with his poor character as a purported drug user, despite no proof that this is the case, rather than evidence associated with charged offense. Any marginal relevance the evidence may have, which Spencer does not concede, is outweighed by the dangers of confusion of the issues and unfair prejudice, and must be excluded pursuant to Rule 403 accordingly. The trial would become about whether Spencer is a drug user rather than whether he committed a crime or was justified in killing the alleged victim. Quote, it is particularly prejudicial when, as here, quote, the proffered evidence connects a party with a highly charged public issue, such as narcotics, and that's US v. Blackstone from 1995. The danger of unfair prejudice from admission of drug-related evidence is great because a drug offense is the kind of crime for which a jury may feel a defendant should be punished, regardless of his guilt as to the charged offense. US v. Sumlin, 2007. This court must exclude the evidence pursuant to Rule 403 accordingly. The evidence does not fit into any exception listed in 404B, and in fact is precisely the type of evidence that 404B exists to keep out. Further, admission of this evidence would violate Spencer's due process rights. See Andrew. Quote, when evidence is introduced that it is so unduly prejudicial that it renders the trial fundamentally unfair, the due process clause of the 14th Amendment provides a mechanism for relief. So this court must exclude the evidence at issue accordingly.
All right. So when I pulled up the supplement here. So in the supplement, they say the smoking device at issue was found in a patrol car at the scene of the shooting. Reports detail the events as they relate to the finding of the device. At the scene, an officer placed Spencer into a patrol car, removed him, and then later placed him back in the other side of the patrol cruiser. When Spencer was placed in the vehicle, he noticed the device and immediately notified the officers that it was already inside the cruiser when he was placed there. Spencer immediately denied it belonged to him and demanded a drug screen to prove that he did not use drugs. He consented to a blood draw for this purpose, although if the state ordered the test, the results have not yet been disclosed to the defense. In addition, the ASCL testing of the device yielded a partial male DNA profile that affirmatively excluded Spencer. Based on the information provided by the state, the evidence indicates a lack of sufficient connection between the smoking device located in the patrol car and the defendant, such that the state could not make a sufficient showing that the defendant ever possessed the item at issue to render it admissible pursuant to 404B or for any other purpose. Further, because all signs point to the device having been placed in the cruiser by someone other than Spencer, the risk of unfair prejudice and confusion of the issues is especially great. The question of how the device came to be in the patrol car will also unreasonably extend the trial in this matter. Accordingly, the court must exclude the evidence at issue. And again, they asked for it to be excluded. So, like Bob says, it's so weird, and we could speculate, about all sorts of things. So it could be any of that kind of speculation to as simple as this cop didn't search his car. He was covering his ass by putting it on Spencer, because that's a big no-no. You don't search your car before people get out. You don't, make sure the person who's ever was charged. If this was some kind of, more nefarious than that, I don't know how we go about even figuring something like that out.
Well, I'm going to be doing some digging down in Low Note. So we'll see. We'll see what I come up with. I'm going to be talking to some folks down there. I'm telling you, I'm all in on this one.
Yeah.
This guy's not going down. Not on
Amora of Alesse has been a member for 1 month. She says, thank you for your attention to this case. And she says, nothing here fits what I would expect from this community. I don't understand why Fosler was out on such a low bond and why comes so hard at Spencer. P.S. Arizona has bail bonds.
Arkansas,
sorry.
Yeah, no, I mean, that's what I'm saying. Like,
Yeah.
something stinks here. Something is not adding up. I don't know what it is yet, but I'm going to find out. I'm coming down. I'm just warning y'all. You're going to know when I'm there. So, and you guys are going to know when I'm there. You guys are going to be my protection in case.
It makes no sense. I wonder if it was the judge, like, just pissed that this happened on her watch, on her release, on her, I just don't, Or is there something even more nefarious going on? But like you said, for an elected official, you're elected. This case stinks. No one thinks that it should be charged. If you accept the facts, even as the Supreme Court said them in their ruling, you have to admit that this guy was justified in his actions. Why would someone who depends on the community to hold their job, just the point you've been making, bring these charges? What is going on? And I think
Stinks.
it's the judge. I think
Stinks.
it's the judge.
I think it's
Or it's something worse.
it's beyond the judge. I have no idea if she's complicit, but it's the issue starts with her, but I think it goes deeper.
So just so you guys know, I researched Fosler's docket. Everything's sealed. There's nothing on there of any sort of substance at all. Not even an information, no facts at all, just his charges. I'm going to see if I can file some sort of freedom of information for that information. I don't know, but based on their ruling, I do think that you should file a motion to be allowed to record in the courtroom. Cameras in the courtroom. Bob Mata.
Yeah, I don't know. Modified sound.
Modified sound.
Yeah, I from all my research, it doesn't look like they do that down there.
No, well, the Supreme Court said, let me find it. This court has recognized an accused may assert his constitutional right to a public trial by arguing that the exclusion of the news media violates that right. But maybe that's just the exclusion of the media from sitting in the courtroom. So I can't take it back. I guess I don't know for sure that they do allow it.
Yeah, I don't know. I mean, we'll try. I mean, either way, if I have to sit through another trial trying to take notes, then so be it. But, it's not the preferred way to do it because you miss so much of the trial itself by trying to write the whole time. And, and then you get loonies out there when you miss something when you're trying to write thousands of words over the course of a day on a yellow legal pad or whatever I had, small notebooks, that I'm trying to lie. It's like there's no winning with that, because you do the best that you can.
History and Homicide said, be careful down there, Bob. I'm going to come with you and guard your back.
Yeah.
And have you trouncing around with no protection.
Yeah.
I got you, babe.
Thanks, babe. I want you down there with me. Like Allie is not shy about knocking on doors and getting in people's faces at all.
We can see if your cousin, if we go on,
We're
going to go down on weekends to do that aspect of it, not the covering the trial aspect of it. Maybe your cousin's daughter wants to come. We take Scout and her, take them to your uncle's.
Oh, you mean, yeah, you're talking about my cousin.
Yeah.
I've got people down there. I've got a spot. I've got a home base down there. So, right around that area. No, we
would leave her at safe and sound at Bob's uncle's.
Yeah.
In a location undisclosed.
Yeah. So, now we're going to be doing a lot of digging into Fosler himself. And, I mean, the reality of that is that
thanks, Kin.
Anything that we dig up and end up talking about with respect to who Fosler actually turns out to be beside what we know, is not going to be admissible in this trial. It's like, that's like reverse 404B, like where you're trying to spread shit all over the victim, so in terms of the admissibility of that, I can't see a way that it'll get in.
No, like we said at the onset, it's what Aaron knew.
Right. So for us, for the public, let's find out who this guy was.
Yep. He's definitely got other victims out there. We'll give voice to them. So if anyone wants to contact us, you can reach us at what's that email address that the girls set up?
Girls, throw the emails. Like
It's like a true crime podcast at gmail.com, I think.
they'll throw it up. They'll throw it in the chat. Um,
I hate no holla back, girl.
Yeah. So our next thing I think will probably be a deep dive into Fosler. So be looking for that, and I'm hoping to get that together here in the next week or so, couple weeks maybe. Yeah, I mean, clearly, like I know things that he was definitely law enforcement in Indiana.
Class, you just missed this. Did you see that when you said that?
Yeah, I mean, there's no question he was law. You know, I knew where he lived. I know where he lived. You know, I know where he moved to after he left Indiana. I've been doing digging. I'm on to him. And I think that the more we get this out there, the more people are going to come forward and want to talk. And by the time this thing goes to trial, we're going to know everything we need to know about that guy. And it's all going to be out there for the public to digest so that we have a clear understanding of the public service that was done by Aaron Spencer in this case. But all right, is there anything else you want to go over tonight, babe?
I don't think so. I think that's it.
Okay.
People need to
All
hear
right.
me rant about Arkansas law.
Yeah, it's got all the earmarks of a case that, again, we are a defense attorneys channel. We are a home for defense attorneys. We are going to trumpet defense attorneys because they deserve it. It's just another example of why you need defense attorneys in this country.
Yep.
You know, this case is a perfect example of why you need defense attorneys in this country. Because it happens. And when the government comes for you, there's one line of defense, and it's us. It's us. So, and
Unsung heroes of the justice system.
people
Defenders
like
of the Constitution.
and Michael Kaiser, you know, doing the good work out there. So, all right, y'all, that'll do it for tonight. We wanted to shed a little more light on this case. I'm not going to allow it to fall out of the public's mind.
You missed it earlier. We had a comment from Aaron's wife was in chat.
Oh, that's awesome. That's awesome. All right, you guys, we want you guys to have a wonderful rest of your weekend. And Allie and I are traveling to New Orleans next week. I'll figure out a way to do some lives out there. I'm excited. I'm recording with a legendary defense attorney for the traditional podcast. I may actually try to film some of it so we could put some of it up on, but it would be video style, not lives.
Right, but you could always have him on a live once you get ready to start.
100%. Like this guy's got this attorney. He's a legendary Louisiana attorney, and he's got some unbelievable cases. You know, like I had a couple of phone calls with him, and he was just telling me about the cases that he's worked over his lengthy and fabulous career, and some of it's just unbelievable. I mean, he was the first lawyer in the United States. He basically developed battered woman syndrome. He was the first lawyer to use it.
You have to check that date with your dad's.
Yeah, no, I think
Your dad's, it was a daughter, but the same concept.
It's gonna vet out. It's gonna vet out. I have a feeling. So he's an amazing attorney, and when that gets out to the regular podcast, I hope that you guys all listen to it. But it's going to be I'm excited about it, and it should be a fascinating listen for certain, because he's a good storyteller, like most defense attorneys are. Most of us can tell a pretty decent tale.
And enjoy the rest of your weekend. If you're from the Arkansas area, you know information about this, you can email us at a true crime podcast
Wait, did they put
at
it up?
gmail.com. I didn't see it.
They didn't throw. Mandy, throw the email address up, please.
It might be pod, not podcast.
I don't know what it is. I don't know what it is.
A true crime pod or a true crime podcast.
I know there's a command for it. If I could just learn the commands and commit them to memory, then I'd be able to throw them up.
Or you can do insider at defensediaries.com.
Yeah, that's ours. That comes directly to us. The insider at defensediaries.com. So either way, there it is.
Here it is. A true crime pod at gmail.com. A true crime pod at gmail.com.
All right, good. So yeah, if you're out there, if you're from the area, if you're from Indiana and you have any information on Fosler, reach out to us. We want to hear
what's going on in the politics out there, or
anything that's relevant to the case. Reach out to us.
Let us know.
You've got a platform here. All right, y'all. Mods, thank you very, very much for your
very much
weekend.
Thank you, Tracy and Mandy.
Saturday mods or Saturday lives, but we put the mods to work today. Yeah, Mandy and Tracy. Mandy's going through some personal things, so thank you very much for taking time out and hanging with us and getting the thumb done. Appreciate you more than you know. And Tracy, we love you desperately. And to all you mods, we love you guys. And thank you guys for hanging with us on a Saturday night. Go watch a movie. Get off the YouTubes. But make sure you come back on Monday or Tuesday when we're back. Because without y'all, I'm just an old man.
Sitting around talking to his wife.
Boop.